The right to be forgotten is the right to have personal information of a person publicly available removed from internet websites, databases, and other public platforms so that search engines cannot find them. It also empowers individuals to ask organizations to delete their private information from such online platforms. The right to be forgotten is recognized as a statutory right in European Union under General Data Protection Regulations. In India, there is no such statutory laws and regulations regarding it. In the case of K.S. Puttaswamy versus Union of India, it was stated by the Supreme Court that the right of an individual to exercise control over his personal data and life would also encompass the right of that individual to control his existence on the internet. Personal Data Protection Bill 2019 recognizes right to be forgotten. Section 20 of the PDP bill says that a person who generates the data or to whom the information pertains can ask rightfully to restrict the information or prevent the continuing disclosure of their personal data. To erase data under this section, it is necessary to establish that the information no longer serves any purpose, or the consent of the data principle is withdrawn, or it is contrary to PDP bill or any other such law. The right to be forgotten is established by an adjudicating officer after the application is filed by a data principal. The adjudication officer needs to take various things into consideration like sensitivity of the information, relevance of that information into the public domain, its effects on that individual or the data principal, and also the accessibility of such information in public domain. Recently, TV personality and MTV Roadies winner Ashutosh Kaushik has approached the Delhi High Court and asked to remove photos, videos, articles, and other information from Google and other related sites available online. The counsel of Ashutosh argued that despite being there no statutory law related to right to be forgotten, it can be exercised, and asserted the relevance of PDP bill and stated that right to privacy comes under the ambit of Article 21 of Indian Constitution of right to life. Another important case law was of Joravar Singh Mundi versus Union of India, in which Delhi High Court passed an interim order directing Google and Indian Qanun to remove judgment pertaining to American citizen of Indian origin Joravar Singh Mundi. The decision was given by the Delhi High Court after he stated that the information available of him online affected his social life, personal life, and even his career prospects. In 2019, Zulfikar Ahman Khan also approached court stating for the removal of 2 articles written by Quint of him, and the court directed for the removal of articles from the platform and also prohibited republication of such articles while pendency of the suit. The Karnataka High Court took into consideration right to be forgotten in sensitive cases involving rape and reputation of the person. The Orissa High Court stated it as a remedy for the victims of sexual exploitation. The Madras High Court recently passed an interim order stating right to be forgotten as an important facet of right of privacy of an individual. In an anonymous writ petition filed where the petitioner approached the court under right to be forgotten when he was charged of criminal proceedings under section 376 and 417 of the IPC. It has been seen in the past years that the cases involving right to be forgotten has rapidly increased, and high courts of different states are accepting this right with varied approaches. The right to be forgotten is an inherent part of right to life and privacy of an individual. It is very important to make stringent laws regarding it because it has become very easy to now access information online due to increasing digitalization. The central government is also in the process of finalizing data protection bill. But there are some issues with right to be forgotten as well, like sometimes it can come in conflict with right to information or freedom of press in the country. It is an undeniable fact that the time has come to acknowledge this right and balance out issues related to it. The increasing number of right to be forgotten applications highlight the issue for Parliament to enact proper statutes and mechanisms related to it, or to amend Article 21 of Indian Constitution, which is related to right to privacy and right to be forgotten. Hence, the statutory and constitutional inconsistencies related to right to be forgotten needs to get resolved by balancing out right to privacy and freedom of speech and expression.